So I am from the private respondent and I have the consent of the petitioner, my lord. My lord, the matter may be adjourned today because we will be filing our affidavit today itself, my lord. I'll serve the copy to the petitioner.
38.
38. Next week, my lord.
Anyone for the
Petitioner.
petitioner?
Petitioner, my lord.
Any objection?
No, my lord.
38. The submission made by Mr. V.K. Babu that they would like to file their affidavit and stands deferred to be listed after 2 weeks. Yes. Mr. J. Loskor appears for the petition. Yes.
Next week.
Next week it is a partnered matter. So after 2 weeks.
Are you obliged?
May I please, Judge Lords? My Lord, I beg to mention for urgent listing of a matter regarding medical admission. My Lord, I have qualified the need. Now, my Lord, those candidates.
You have filed it
Yes, my Lord, filed it number.
Monday?
My Lord?
Monday?
No, my Lord, today is the last date for.
Today.
My Lord, is the last date for the second counseling is going on, my Lord. Finally, my Lord.
What were you doing yesterday, day before?
No, my Lord, this petitioner came to me, my Lord, at 10 p.m. night, my Lord. We have worked for him, my Lord. It's a matter of his career, my Lord. Finally, my Lord. Otherwise, obliged, my Lord.
Your Lordship, the consent of the petitioner Lordship, I beg to mention item number 27. We are here, Lordship, we are going to file our affidavit here today.
27.
Lordship.
Right. 27. Mr. Dekka,
Lordship.
any objection?
No.
On the submissions of the council for the elementary education of his S4 matter stands deferred to be listed after 2 weeks, enabling them to file as they are filing their affidavit today.
Today, Lordship.
The petitioner is also at liberty to file their rejoinder if so advised. After 2 weeks.
After 2 weeks.
Second.
Lordship. 2nd of September.
September.
May it please,
My Lord, the consent of the other side, my Lord. I beg to mention item 49 and 50. My Lord. We are supposed to file the affidavit, my Lord. However, company instruction not received yet.
49 and 50.
My Lord. Kindly, yeah, up to 3 weeks, my Lord.
49 and 50 matter stands deferred on the submissions made by Mr.
Yes, that's
S. Das for higher education.
Madam.
Mr. A. Dekka,
Lordship.
also on second.
Lordship.
You want it on second?
Lordship, second.
Just on 2nd September.
3 weeks, my Lord.
Huh?
3 weeks, my Lord.
You wanted 3 weeks. All right, 3 weeks, then
10th of September, Lord.
11th.
Lordship. What's up?
May it please,
Okay.
Your Lordship. Item number 7, Lordship. We have filed our affidavit today itself, Lordship. That may be called for, Lordship. Item number 7.
Item 7, affidavit to be given.
Obliged.
May please, Your Lord. I have filed an IA, my Lord, in the connected writ petition. For striking of the names, my Lord. That main appeal is fixed on 20, my Lord. 20 of August.
You want it on 20.
Yes, ma'am. Same date.
You, I have to be listed on 20 August.
I'll give them.
I beg to mention item number 28. I have taken consent from the Authorised also.
28.
28. It will be taken after a week.
28 on the request of the council to the petitioner stands deferred to be listed after.
Lordship, with the consent of the other side, I beg to mention item number 23. I'll pray for an accommodation only for the day, Your Lordship.
23, the request made by the council to the applicant writ petitioner
Yes, Your Lordship.
stands deferred to be listed after 1 week.
Deeply obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 19 be urgent today.
19.
Yes, yes. I need some more time to file affidavit in opposition.
You are mentioning on whose behalf?
On behalf of respondent here.
Have you informed the
Yes, I
petitioner?
have taken consent from the other side.
19 on the request of the council to the respondent stands deferred to be listed after.
No, no. End of the 3rd week of September.
After 4 weeks. Yes.
Yeah, Judge Lords. I beg to mention for listing matter, my Lord. Admission.
Admission. 19.
Obliged.
Lordship, with the consent from the other side, I beg to mention item number 43. Lordship. But here I am praying for some accommodation on behalf of council, senior council, because the S board have Lordship. But we are awaiting certain instructions. Can it be taken up on Monday, Your Lordship?
43 on the request of the council for the petitioner stands deferred to be listed on Monday.
Lordship.
You are appearing for H. Borwa for?
SSA, my lord.
Yes, yes.
Lordship.
May I please?
Item number 44, I am not a petitioner in this case. We talked with the Respondent Council. They want to settle the dispute in the court.
Either for mediation, wait until the matter is called up. Let the matter be called up.
Ma'am, on behalf of Ms. K. Devi, for item number 35 and supplementary item 54, kindly please pass over the matters for today and kindly please list the matter for next week on Thursday.
Item 35 and
Supplementary 54. Item
54 on the request made on behalf of MSK Devi. Is will stand out and be listed next week. 19th.
My please, Your Lordship. Lordship, I beg to mention for Udra Lordship, WPC number 135/22.
Monday.
Obliged.
My lords, I am appearing in item 1 virtually.
Yes.
Apologize, my lords, I am not there physically.
We don't have to apologize. Virtual appearances are
I
permitted.
am so obliged, my lords. My lords, this is an arbitration petition under Section 11 of the Arbitration Act. I appear for the petitioner. I am a lessor under a commercial lease agreement. The respondent is the lessee. And the respondent, my lords, I may indicate, is a well-known media house in Gauhati. My lords, may straight away come to page number 11 of the paper book, which contains the arbitration clauses. I just want to show the arbitration clauses, my lords, and I want to point out that this is not a case where the existence or the validity of the arbitration. Page number 11, my lords. Page number 11 of the paper book, the arbitration petition, has the 2 arbitration clauses. There are 2 agreements here.
Why don't we go to the agreement itself?
Absolutely, my lords. My lords may straight away come to page number 31.
31.
Right. 31, my lords, contains the latest lease agreement between my client and the respondent. It is a 2025 lease deed dated 18th of July, 2025. My lords will find the arbitration clause at page number 37, clause 19. If I may be permitted to read, my lords.
Page number,
page
number 19.
Clause number 19 at page number 37 of the paper book is the arbitration
Yes.
clause. The parties have essentially agreed that they will resolve their disputes through binding arbitration. The seat of the arbitration is Gauhati. So this is the first arbitration clause, my lords.
Okay. Yes.
And the second arbitration clause, my lords, will find at page number 46.
46.
Right, my lord. So essentially, if I may just quickly take a minute to explain, at page number 46, my lords will find an addendum to the 2024 lease deed, which also contains an arbitration clause. Essentially, they are the same arbitration clause.
Okay.
Here also, the parties have mutually agreed that they will resolve their disputes through arbitration. My lords, the notice invoking arbitration will, my lords will just note, is dated 21st of January 2026. And my lords will find the notice at page number 53 of the paper book.
53.
53, my lords. This is essentially a case, my lords, where rental dues since 2014 has not been paid to my client. So we sent a legal notice, no response. Thereafter, we invoked arbitration, no response. And as a result of which, we were constrained to approach this honorable court under Section 11. I may also indicate that we had filed a Section 9 petition before the learned trial court, and we also obtained a favorable order before the learned trial court. So at 53, my lords will find the notice invoking arbitration. At page 57, paragraph 16 is where we suggested 3 names for appointment of a sole arbitrator, but the respondent did not respond. Instead of responding to the notice invoking arbitration and in the presence of an arbitration clause, they went to the commercial court to file a suit seeking injunction against termination. So we had to file a Section 8 before the learned civil judge to get the plaint returned and refer the matter to arbitration. All those orders, my lords, have been placed on record. The Section 8 order and the Section 9 order. Both orders are in my favor. I would just like to point out one more thing, my lords, before I conclude.
What was the order passed by the civil judge?
My lords will see at page number 61, At page number 79 is the order of the learned civil judge under section 8, whereby he dismisses the plaint filed by the respondent and refers the matter to arbitration. The relevant portion starts at page 96, my lords. Page 96, paragraph 28, 26 onwards. Now, in this case, after perusal of the documents on record, as well as the reasons mentioned above, this court is of the view that the application filed by the petitioner under section 8 needs to be allowed for the reasons indicated above. Overleaf, my lords, at page 97, para 27.
Yes.
In light of the above reasons, the parties are referred to arbitration in terms of clause 19 of the agreement of lease dated 18/7. My lords have just seen this particular clause. Let the plaint filed in CS so-and-so be returned to the plaintiff for presentation before the Honorable Arbitral Tribunal. This court is also of the view that the interim order passed in so-and-so stands vacated. They had actually suppressed the fact that there's an arbitration clause and obtained an interim order in their favor. That also stood vacated on this particular date. After this, my lords, there is also, in fact, prior to this, I may just indicate for the sake of full transparency that we had approached the Honorable Civil Judge for interim reliefs under Section 9, and even that order has been placed on the record. We've obtained favorable orders under Section 9 as well, my lords. That order, my lords, will find at page 61.
Okay. Heard. Mr. Rangan Chaudhary. The counsel appearing for the petitioner. Is an application under section 11(6) filed with petitioner.
My lords may say 11.5, read with 11.6, my lords.
11(5)/11(6), read with 11(6). Petitioner entered into an agreement with the respondent. This is a lease agreement.
This is a lease agreement, my lords. It's a lease agreement that started in 2012 and got renewed every year. The latest lease agreement is of 2025. As on today, the lease stands terminated because of non-payment of rental dues, which is what we seek to recover through the arbitration, essentially.
Because of lease agreement, because of non-payment of the rent as agreed to, differences arose between the parties, and in terms of the arbitration clause at clause 19 of the agreement of the lease deed, the notice was issued in section 21, calling upon the respondents to concur on the appointment of the arbitrators. Stop. The notice was replied to.
No, my lords, there was never any response to the NIA.
No response was received in to the notice, the 21, issued by the petition. Stop. Instead, the respondent approached the civil court, obtained an injunction, and subsequently the said order came to be vacated by the civil judge by order dated
35 yes, my lords, 30 May
2026, whereby the respondents were referred to arbitration in terms of clause 19. The lease agreement dated 18/7/2026. Claim was returned, and the interim order which was passed was also vacated. Stopped. Since no response was received by the petitioner, this application has been filed. Whereas having heard counsel for the petitioner, issue notice, return within 4 weeks. Steps of the respondent by speed post.
My lords, we've already, I've already served them through email. We'll also serve them through speed post, my lords.
Speed post. Taken by speed post within 1 week from today. Matter be listed after the returnable date. If you want to take Dusty, we can permit that.
Yes, my lords, that will be.
Service by way of Dusty is also permitted, provided the same is written to the registry of the court.
My lords, I just want to point out one thing, my lords, before I conclude. My lords, this is actually a case where even the other party agrees that there's an arbitration clause. Therefore, my lords may kindly give a shorter date than 4 weeks, my lords. I may just want to point out one thing. If my lords just come,
Because we have ordered service by speed post.
all right, my lords.
At least 3 weeks.
Yes, my lords may make it 3 weeks instead of 4 weeks, my
3
lords.
weeks. All right.
Obliged, my lords. Obliged. Grateful, my lords.
This case, my lord, directed to bring inspection, my lord, I need some time.
Yes. Further time is paid for by Mr. P.K. Boran, counsel for the respondent. Prayer made is objected to release this matter again after 2 weeks.
Here also I am paying for some time.
Time order.
Obliged.
Yeah, please, Your Lordship.
Yes.
In this case, my lord, I have passed bachelor of pharmacy degree, my lord, and applied for registration before the
Who's for the pharmacy council? Who's to give you the license?
register, my lord, register pharmacy council.
Registrar Assam Pharmacy Council, who appears? You're there, Mr.
Yes,
Bhuiya?
Lordship. Yes, Lordship.
Please get your instructions.
Yes, Lordship.
Matter be listed after 2 weeks, enabling Mr. Bhuiya, counsel representing the registrar Assam Pharmacy Council to obtain instructions in the matter. Although notices are not issued, extra copies will be furnished within 2 working days
Lordship.
to enable him to obtain instructions.
My lord, date may be fixed, my lord.
2nd September.
Obliged.
Obliged.
May I please, Your Lordship? The financial upgradation under MSCPS, Your Lordship.
That counsel for parties issued notice returning in 4 weeks. Mr. SMT Chisti. Yes.
1, 3.
Behalf of
4 and
respondent 1, 3, 4 and 5. MS appears for respondent number 3. The respondents are represented. Notices are waived. Extra copy will be furnished within a period of 1 week from now.
Hello.
Yes.
Well, prayer for regulation of music teachers, man. I think at this stage, man, notice has.
Heard Mr. P.D. Goswami issued notice. Return over 4 weeks.
All government
Steps, Mr. SMT Chisti appears on behalf of all. Therefore, notices are waived, extra copies will be furnished within a period of 1 week. This is pursuant to the Supreme Court judgment.
Similar cases are fixed on 23rd of September, Lordship.
It is submitted that similar matters are fixed on 23rd of September. Accordingly, this matter be listed on 23rd of September. Do we have any number?
That number, Lordship, I have to get it. Right now, I don't have.
23rd September.
One second.
Seven.
Seven to 7 hour.
Here's item 8.
Provincialization of music teacher, man.
Yes. Third counsel for parties.
Similar case.
Mr. SMT Chisti appears on behalf of
Respondent
1, 3, 4. Finance, who appears on finance,
Yes,
and
yes.
thereby appears on finance, since the respondents are represented by the respective counsel. Notices are waived, extra copies be furnished within a period
23rd
of
of
3 working days. Matters, since it is submitted by the respondent counsel that the similar matters are fixed on 23rd of September, this matter will be listed also on 23rd.
obliged.
Oblige.
Should kindly the matter will be passed over for my senior is at Lex.
Monday,
So, Lordship, today on is at Lex.
timing.
Lordship, here I'm praying for upgradation of my service from tutor to assistant professor, Your Lordship.
Third
Lordship,
counsel to the petitioner, yes.
no, Lordship has issued notice in an identical matter.
Third counsel for parties. It's Mr. S.
Yes, sir.
Das.
I'll
In
be
case
okay.
we have responded for 1, 2, 3,
And 4 months.
4. Therefore, pieces of respondents 1 to 4. Are waived, our extra copies will be furnished within a period of 1 week from today. Steps on respondent number 5 by speed post within 1 week from today. Released after returnable date.
Here, Mr. Lordship. The BTC authority has issued an embarrassment lordship. Lordship will find that embarrassment at page 41. 41 for filling up the post of assistant teacher in LP and ME schools. And here lordship, there are 3 number of petitioners. They have applied for the post of assistant teacher in LP and ME school lordship. This is advertisement issued on 20 June 2025. Thereafter lordship, we have applied through online and we participated in the selection process. Now, BTC authority lordship subsequently on 31/2026 at page 58, they have issued a notice whereby candidates are requested to appear before this screening committee. And accordingly, we have appeared lordship. Now, thereafter, the authority published the select list and issued the appointment order. Now, we came to know that lordship, we have not been selected. And later, we also came to know that lordship, the marks allotted for the DLED degree that has not been given. So immediately thereafter, the petitioner approached the authority and filed its presentation, and this representation is yet to be disposed of, lordship. And furthermore, lordship, pursuant to this advertisement, lordship, the authority has also not disclosed the total number of vacancies, and the select is also not prepared, lordship, district-wise, which is, lordship, as per the advertisement, they are required to, lordship.
We'll issue notice there.
It is about, lordship, the number of whose may not be filled up, lordship.
That
Because we are belong to the BTR region, lordship, but the candidates who are outside the BTR, they have been selected, lordship.
Mr. Mia, Senior Counsel, assisted by NR Sharma, APS for the BTC authorities all. Respondent number 2.
1 is government.
2, 3, 4, 5. Is there score to respond? Petitioner is the same. The select list published.
Yes, if I appointment also letter of issue.
My lord, the facts are like this, my lord. Here in this case, in the month of January 2024, selections advertisement were published, my lord. August 2024 selection process is over. Now, my lord, in 2020,
Advertisement is of 20th June 25.
I'll come to that, my lord. Subsequently, thereto, in December 2025, my lord, a case which was dismissed by the Supreme Court, subsequently in December 2025, a judgment comes in a review petition, wherein it is arising out of a case of Uttarakhand High Court. Now, thereafter, in that particular review applications from, so far BTC is concerned, there were 56 applicants. These 56 applicants filed for impleading, and that review judgment talks about one-time measure for appointment of neos, my lord, who have obtained diploma degree of 18 months. And that is on the basis of, my lord, right to compulsory education of Act of 2009, wherein 23 is a provision, wherein 23 talks about that those teachers who are in employment as on 10/8/2017 can acquire this, my lord.
So for today, we are only issuing
Notice, my lord. My lord,
You get your
yes.
instructions.
Yes, my lord. And there are similar writ petitions, my lord. May I break?
Issue notice.
So that order already your lordship has this was page 35. People permitted lordship, that DLED qualification is also allowed lordship. Page 35 your lordship's order. The petitioner lordship before you.
No,
Yeah.
Here you are challenging the selection.
Selection lordship. Now, where came to that the 5 marks allotted for DLED, that not has been considered by the authority. So that's why lordship we have not been selected. Lordship may for the record.
Others are aggrieved and received the select list published by the responsible authority. The interference selection process undertaken pursuant to the advertisement dated 20th June 2025. Petitioners, the candidates have submitted their candidatures. And according to the petitioners, they fulfill all the eligible criteria. However, it is from reliable sources, they have been informed that what is not counted? DLED degree.
The DLED, for DLED qualification, the petitioners is supposed to get 5 marks. That marks had not been given because they have
DLF.
passed the
What is it called? DLF.
diploma in elementary education.
Diploma in elementary education, which the petitioner that completed, the respondent authorities did not allot any marks. Is the submission of the counsel to the petitioner, and under such circumstances, the respondent authorities ought to have allotted the marks which the petitioners were entitled to under law, and that not having been done, the respondents were left out of the select list. Accordingly, the directions are sought for against the respondents. We are considering the issues that this issue returned in 4 weeks, and Mr. Mia and also appears for the respondents. There were notices are waived, extra copies be furnished within a period of 1 week from today. Issue notice on the. We'll say that the appointments made.
Oh, already it was a kindly see the the number of vacancies are not notified. And the candidates
We
who are
will say that the appointment made 3 posts.
3 votes, not to be
Shall-
filled up.
Huh?
The number of posts not to be filled up, Lordship.
No.
Because-
3 posts if filled up. All the 3 number of posts shall be subject to outcome of the writ petition, subject to there being no other available vacancies.
Why not here the selection process of 2025 is not even processed, my lord, till now because of the stay of the.
So also kindly see the notice then.
Then what
Page
select list are they
58.
challenging?
Page
Where is
58.
the select list, my lord, to 25?
Where is the select list?
Let's see, page 58. Page 58 is the notice, 30th January 2026. May I read, Lordship?
Thereafter,
have
we
the
have not
select list?
processed. No.
We have the select list.
I have not, Lordship, received a
Right.
copy of the select list,
Select
but the
list
appointment
is
order
not
is issued.
numbered.
That appointment order is, Lordship, 10th of April 2026.
Yes, that is with regard to Supreme Court, my lord, a contempt petition, my lord, with regard to the accommodation of the honoring the Supreme Court judgment, my
All
lord.
right, the counsel for the petitioner will place on record the select list.
Yes.
Pursuant to the selection in which the writ petitioner submits that their names were not included
Right.
by the respondents for their failure to allot marks to the
DLED.
DLED
DLED.
diploma, which was undergone by the writ petitioners. Released after the returnable date.
That observation will be given, Lordship.
What observation?
3 number of
No,
post,
no.
Lordship.
You give the select list first. Bring the
No,
select
I have,
list.
Lordship, bring the appointment order, Lordship.
The appointment order relating to which select list?
This advertisement.
No, my lord.
No, Lordship, kindly, for a moment, kindly see page 58.
Why
Page
have you not?
58.
Do you have a copy of the select list?
Right now, I don't have the copy of the select list.
There is no select list, my lord.
Page number?
Page 58. My learned senior has submitted that the selection
58.
is yet to be complete. Page
Yes.
58.
Yes.
This is the first notice, 30th January 2026. This has been issued person. May I read, Lordship? It is hereby informed to all the candidates who had applied online for the post of assistant teacher of LP schools in connection with the advertisement dated issued on the 20th June 2025 are hereby requested to appear in the scrutiny verification of academic and professional qualification to be held on 71/2026 to 20th January 2026. So thereafter, Lordship, on this date, Lordship, the scrutiny was not done. They rescheduled the date, Lordship, for scrutiny. Now, Lordship, kindly come to page Lordship 62. 20th January. Due to unavoidable circumstances, the scrutiny verification of academic and professional qualification for the candidates who had applied online for the post of assistant teacher of LP schools.
Fresh date is rescheduled.
Rescheduled.
And
Then accordingly, our documents have been verified.
Then
My verification has been done on 30th February 2026 and 24th January 2026. So after Lordship completion of the verification process, Lordship, they have prepared the select list. And on the basis of that select list, Lordship, this appointment order 10th of April 2026, page 67.
No,
It has been issued to the LP school teachers.
no.
Then immediately Lordship approached the authority and filed this representation.
Absolutely no.
Page 67.
This does not have any reference to the selection process undertaken. Which
Yes, my lord. This is different, my lord. With regard
Which
to
year?
the contempt
Lordship?
petition file.
Which year?
No, see, in pursuance of just approval of the BTC authority and subject to discharge.
Where is that approval order?
Approval 10th of April 2026.
Where is that order?
It is after BTC authority.
That's right. So
Lordship.
from
Yeah.
this order, how do you say that it relates to that particular advertisement
It's
or
not-
selection process that you had entered, applied for? There's no reference.
My lord can note my submissions, my lord. Selection process has not culminated till now.
No, already Lordship, the document verification process is
You furnish
completed.
the select list.
No, it is the Lordship, we did the BTC authority, Lordship. I may Lordship approach the authority, but
All right, on the next returnable date, the
The
BTC
authority will
authorities
produce
will apprise the court the process of selection to the manner which was pursuant to which the order dated 10th of April 2026 and
Fine.
H.R. 8, page 67 is
My lord.
issued.
My-
problem.
Yes.
May I please, your lordship? My lord, the petitioners are working as a graduate teachers in the, my lord, amalgamated high schools and secondary level schools.
Great pay.
Great pay. My lord has already heard, and similar matters are also pending, my lord. And, my lord,
Council for parties issued notice in returnable 3 weeks. Mr. SMT Chisti
On the response.
appears represents of the respondent.
Lordship, two and three, Lordship. One is the government.
2 and 3. MSS going to respondent 1, since the respondents are represented. Notices are waived, extra copies be furnished within a period of 1 week from today. Stop. It is submitted that similar matters are fixed on.
No, this is different, Lordship. Lordship may issue notice on.
no, exactly.
And
similar.
released
Similar.
it.
My lord,
Doesn't return.
my lord may be pleased to take along with, my lord, one of the
Okay.
similar.
Let it be after the returnable date.
Fine.
You can pass that order after return.
Yes. Right.
Please, your lordship. My lord, the petitioner is serving as associate professor in medical college. 40 years back, my lord, in the year 2086, my lord, he was given CEDUCAT certificate. On the basis of this certificate, my lord, he got his medical admission in the year 2087. In 2001, my lord, he has cleared his MBBS and he has also cleared his MD, my lord. After 40 years now, somebody made a complaint that his certificate is not correct one, my lord. So an inquiry was made, and in the inquiry, my lord, first of all, vigilance inquiry was made. Then the scrutiny committee looked into it, and they gave a report. There is no evidence about that he belongs to, my lord, scheduled caste community. So on that basis, his scheduled caste certificate has been cancelled. Now my sample will be today, my lord. Worship will examine this matter, and so far, my lord, the others, no coercive action will be taken because there is judgment of the Supreme Court of this year, my lord, February month, similar case, absolutely, my lord. Just have a look at this, my lord. And kindly consider, my lord, this February, identical of this case, my lord. Luckily, I got this judgment. If it can protect me, my lord.
Yes.
My lord, this is the judgment of 25 to 26 by the Supreme Court, my lord. Here, what has happened? These two persons, they got scheduled tribe certificate. They got admission to medical college. They completed 5 years course, but certificate person was not given. They came to the court, my lord. The petition was dismissed. They went to the Supreme Court ultimately. Supreme Court says, my lord, no.
since that cannot be undone now. That post can be given to anybody else. So since there's a lack of doctor in India, my lord.
You come to para 11.
My lord.
See, what does it say? Read.
I've seen my lord.
Read it for our
The order requiring university issue degree certificate has been passed in such and such 142. There is 142. That's all right. So from this one is concerned. But before that, my lord, there is 7, my lord. That is regarding that part. My condition, my submission will be, my lord. So far, lordship may examine this, my lord. In terms of this paragraph 7, my lord.
If you rely on the judgment, allow us.
No. That part only we have to rely there. 7, my lord. Per corporate article 20 of the hands shall not be treated as precedent, my lord.
We dismiss.
That is okay.
You go to the Supreme Court.
Oh, it's all right, my lord. Kindly see this part, my lord. That 40 years out of 40 years. 30 years he's, my lord, teaching the students, my lord. He's all these things he's doing.
But under the wrong, you've taken the benefit.
My lord, any action may be taken if they ask me to undertake. No promotion required. I'll do anything, my lord.
No, which means that you admit that you don't belong.
My
to
lord,
the
my lord, they have given, but there is no findings that fraud was played. During 40 years back, my lord.
If you don't belong and you have a certificate, is it necessary to prove that fraud was played?
That is true, my lord. That's the reason, my lord. It's a hard case. It's a hard case.
How is it a hard case?
Hard case. But
either you say, do you belong or you don't belong?
No, my lord. Actually, the petitioner says that he belongs to Baniya community. And Baniya community from Afarasam, those days, they were given silver certificate. That's what the stand is. Then they went to his father. His father is 86 years old, my lord. He also could not provide anything, my lord. He stays in a village now. That's what, my lord. Now, he is Sabo in around, my lord, 30 years now, my lord. He's an associate professor now. Just the language in paragraph 7, my lord. That's why I'm saying, my lord, my lord. I know fully well, my this
you produce the relevant orders under which this community was, if at all,
my lord, I assume, my lord, since they are giving the certificate that is wrong, my lord. Assuming this is wrong, my lord. My submission is on basis of paragraph 7, my lord. Since, my lord, 40 years is a long time.
That's
right,
right. This reference to para 7 is under 142, which we don't have power.
That's true, my lord. That's true.
If it is true, then why are you asking us?
No, my lord. This is the one example.
My
lord, this is the one example I have seen, my lord. Even lordship was the 226 enough. Lordship is also got, my lord. But order 226, my lord. Even in Barnard case, my lord. In a Barnard case, land acquisition case.
You place and tell us that we got equivalent powers like 140.
My lord, forget about keep aside this judgment, my lord. Even lordship will consider. Suppose, my lord, this man has put on 30 years of service, my lord. And he is also imparting educations to the students, my lord.
And forgery.
Forgery for who is cancelled. No, two things. There are two things. One is, my lord, kindly consider this part, my lord. One is, certificate is bad for which is got admission. Second point is suppose wrong. He got admission. Second point, on merit he has passed his MBBS examination. On merit he has passed the MD examination.
But his entry was by way of this category.
But subsequent, my lord. That's why I said, my lord, any condition lordship may put, my lord. At least for the lordship may examine this matter, my lord. I'm saying, even if necessary, I'll give an undertaking, my lord.
By that certificate, he got entry into the...
I got entry, but on merit I qualified, I want to say, my lord.
No, qualification comes later. He has to enter first.
But since
because of him, somebody else...
Something wrong has been done, my lord. Suppose, 40 years has gone, my lord. Now, this period, suppose he is sent back, my lord. Whether this post can be filled up that I have deprived somebody.
That is what the government decide.
That part,
the government decide.
That part.
They are not settling us with this problem. How will we fill up?
My submission is that 30 years, little bit of compassion, my lord. Something little, even necessary. I will say, I'll forgo my promotion, my lord. Anything I'll forgo. Any order passed by lordships, my lord. Just, I will be able to continue. When I'm 57 years old, another 3 years, 4 years left, my lord. That's my only prayer, my lord. Lordship, just examine this matter, my lord. Entire life is spent, my lord. Only few days left only.
Lordship, I have received all the documents, your lordship, the inquiry report, lordship, minutes of the meeting. We have given all the plans, your lordship. We could not produce anything. And inquiry is done in the...
So is it your case in the inquiry that this certificate was obtained by means by forgery, fraud?
Nothing.
Lordship, that is not written here, but inquiry says that all his relatives, family members, all belong to general caste, your lordship.
That's a different issue. Somebody may belong to a scheduled caste, for reasons best known to them or their forefathers, they did not apply.
Yes.
And they may have been considered to be a general caste. Somebody down the line realizes that they are entitled to be there for a certificate, applies, gets a certificate.
That may be your lordship,
Then-
but now the fault has come to notice your lordship.
There's a lack of conclusive documentary
That's what we are
evidence.
asking you, where is the, what fault have you noticed?
Lordship, that is lordship already examined in the meeting, your lordship.
But you get instructions and tell us, right, Mr. M. Nath, Senior Counsel, assisted by MS,
Real Decca, your
DL Decca Advocate for the petitioner, MS R.
Decca.
Decca for the
Response
Social
number
Justice and Empowerment Department, representing respondent number 1,
1
3,
and
4,
4, your lordship.
1, 3, and 4. Mr. D. Upamanyu appears for respondent number 2, and 5, 6. Ms. S. Kumar appears for respondent number 7. Therefore, notices on behalf of respondents 1 to 7 waived. However, extra copies be furnished within a period of 3 working days. Steps on respondent number 8 and 9 by speed post. Custody is also permitted, provided the same is put through the registry of the High Court. Meanwhile, till the next returnable date, coercive action be initiated against the petitioner on the basis of which order?
My lord, that's order number, order page 42, dated 27/5/25.
Order dated 27/5/25 within bracket annexure 14, page 42.
And 27/26,
And
two orders,
26.
page 44.
Page 44. Matter be listed again. Given in the middle. 11 September.
Sometimes hard cases comes, my lord. Sometimes hard cases also come.
Hard for you. For us, it is not hard.
Lordship is equal for everybody. There is no doubt about it.
Not that. It's a hard case because you say it is a hard case. As far
I
as
said,
we
I
are
strictly said,
concerned.
I said. And also there's the lack of evidence, they said. That I'll show.
Pending item 7.
May I please, Madam? Because the petitioners are holders of 18-month diploma in elementary education, Madam. In fact, similar petitioners have approached this court and this court has issued notice and passed interim
What
order.
is this affidavit you have filed?
Page 157.
What is this affidavit?
They have filed on the first day, Madam, the affidavit number.
Filed it because, my lord,
Motion, I received it
We
today, Madam.
have not even issued notice.
my lord, that's why, my lord, to bring on record our case, my lord, because of the fact that there are shortage in teachers, my lord,
Okay.
and interim orders are coming, and the process is not, my lord.
What is your claim?
My lords, may kindly turn to page 157, the interim order, my lords, passed by a coordinate bench. Madam.
Oh, interim order
Yes,
by other bench is
my lord.
different. What is your
My
claim
lords,
before the court?
The petitioners are holder of 18 months DLED, my lords. They participated in the selection process. And during participation, there was a notice issued by the state, my lords, the BTC, that 18 months diploma would not be valid, my lords. Thereafter, my lords, a lot of writ petitions were filed, my lords, and there were interim orders allowing all those petitioners to participate in the selection process, my lords. Hence, they participated, my lords. And in the meantime, my lords, the Supreme Court had clarified Vishwanath's judgment, my lords.
Uttarakhand.
Yes, that 18 months DLED would be a valid degree, and those people who were denied appointment should be given appointment. Accordingly, my lords, 56 candidates participating in the same selection process were appointed by the BTC, my lords. And pursuant thereto, my lords, after the judgment of the Supreme Court, we had approached, my lords. Initially, this order was passed in the other matter, and this is the second. 3 teachers were left out, my lords. They have approached, my lords, by filing this writ petition, my lords. There's already notice has been issued, my lords. It should be tagged with the other matter, my lords.
Your selection, you're rejected.
We were called for the interview. We participated just because of that notification, which was subsequently set aside. We were not given appointed, my lords. We're not appointed.
You're not appointed.
Yes, my lords. The similar order of 157, my lords.
And somebody else is appointed.
No one else is appointed.
No one else. Right. Heard Yes, Mr.
Yes,
Bhuya.
may I point out, my lord? My lord will kindly see, for the convenience of the court, I have filed this matter. Whatever is
How is it convenience of the court if you file
Because
it
the,
at 10:30?
my lord, what I am on with regard to the whole news controversy itself, my lord, will kindly come to page, my lord. First thing, my lord, this particular act itself, my lord, 2009 act that starts from page 176, my lord. I take your lordship directly to provision 23. That is at page, my lord, 185. Yes, 185. Qualification for appointment and terms and condition of service of teachers. Any person possessing such minimum qualifications as laid down by the academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Where a state doesn't have adequate institutions offering course or training in teachers education or teachers possessing minimum qualification as laid down under subsection 1.
Mr. Counsel, please
Yes.
understand.
Yes.
We are yet to issue notice.
Yes.
You have filed an affidavit, that's good. But the question is, what is the relevance of what is the effect of the Supreme Court judgment?
Yes,
In
that
my
I
view.
take your lordship, my lord. Here, this notification of 1/4/2015, my lord will kindly see. This has been amended, my lord. For what purpose? Giving an opportunity to the persons who are already employed. And my lord will kindly see 3. Provided further.
Page number?
My lord, 165 itself, my lord. 185.
185.
Yes, proviso 23 proviso, my lord. Further, provided further that every teacher appointed or in position on 31st March 2015 who does not possess minimum qualification as laid down in subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right to Children's Free Education Act, so and so, so and so. Now, my lord, the Supreme Court judgment I have annexed it, my lord. 1219, my lord.
Yes.
My lord, first judgment, my lord, 192, my lord. These news degree holder, my lord, came to the Honorable Supreme Court and challenged with regard to this. And in paragraph, my lord, will kindly come to. Yes. Operative portion of the judgment, my lord. For para 41, my lord, will kindly see in this judgment. We find that the High Court of Patna was totally error in giving effect to the stand of NCT. As a matter of fact, we fail to understand why NCT did not challenge the said order when its specific stand that this 8-month course was only in service candidate and not applicable to fresh ones was rejected by High Court. We also fail to understand as to why communication dated so and so NCT decided to accept the said judgment of the High Court of Patna. Ultimately, my lord, this news degree is not recognized, my lord. And thereafter, my lord, paragraph 47, can you read it, my lord? At page 207. We further find that the finding of the High Court that the 18 months so-and-so diploma, so-and-so course of elementary area conducted by news is equal to 2 years diploma is erroneous. There is no notification to that effect issued by NCT in supervision of notification dated so-and-so, so-and-so. So it is not recognized. Now, against this, my lord, review petition comes in, my lord. 219, my lord.
Senior friend is reading Jaivir Singh, my lord.
Yes, I am coming to it.
That has been reviewed by the Supreme Court.
Yes,
itself.
I am coming to it. I am the last person to suppress anything.
No,
219, my lord, will kindly come to. These, my lord, so far BTC is concerned, in 2024 selections were, my lord, advertisement were issued in the month of January 2024. It concluded in August 2024. And this review judgment, my lord, date, can you see, my lord? Yes, 10/12/2024. This comes in. But whatever it is, my lord, I am reading the judgment at page 220, my lord. Only 56, my lord, petitioners, applicants were there before the Supreme Court. So far, BTC is concerned. The grievances sought to be raised on behalf of the review petitioners and some of the applicants before this. So 56 applicants were there so far, BTC is concerned. This court is that though they were in employment and covered by the recognition order dated 22/9/2017, they believe that the judgment and order of this court dated 28/11/2023 so and so would come in their way if they want to make better their prospect by applying either in other institutions or for promotional revenue. We have already clarified in the judgment under review that the one-time scheme provided solely to safeguard the interests of those teachers who were employed as on 10/8/2017. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications. However, to avoid any confusion, we again clarify that the 8 months diploma obtained by such persons who were in employment as on 10/8/2017 and who completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Needless to state that the clarification will be effective from the pronouncement of the judgment on the review. Now, my lord, everything has been disposed of. Again at page 227, my lord. This is again a judgment, my lord. And it was this, my lord, same thing, my lord. At page 226, my lord, Vishwanath Pratap Singh, my lord, Vishwanath case, my lord. The relevant para comes in, my lord. 1-4, my lord. At page, yes, 2-3-1, my lord. Kindly see the clarifications again. These court had further clarified so and so order dated 10 December 2024 in so and so, Vishwanath and others versus so and so. However, to avoid any confusion, we again clarify that 18-month diploma obtained by such person who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Needless to state that the clarification will be effective from the pronouncement of the judgment. Now, kindly see my paragraph 23. 23. We therefore direct the state government to consider the claim of the applicants in accordance with the clarification dated 10 December 2024, and if the applicants are found to be eligible, to appoint them in accordance with law, same shall be done within a period of 3 months from today. We further clarify that while doing so, the state government would not reopen the selection already conducted, which has reached finality. Now, this has been a judgment, my lord. And in January 2024, my lord, I have specifically stated in my affidavit that has ended in August 2024. The judgment comes in December 24. And as a one-time measure, my lord.
So essentially what you're saying is that this is applicable as a scheme for only teachers who are employed.
Who were employed on 10/8/2017.
Not for fresh.
No, my lord. And their whole petitions, my lord, they have made a statement they were employed. No documents, nothing, my lord.
Specific averment, my lordship would see my entire petition. Lordship would start from the synopsis, my lord, the first paragraph.
No, why synopsis?
My
Go
lord,
to your paragraph.
my paragraph 2, my lord, in that case.
Yes.
And in fact, I got the certificates also, my lord, today.
You're employed.
Yes. Before the cutoff date.
You examine it.
And
examine it, my lord, no stay there because the bunch of other matters, there are other writ petitions, my lord, yes, which has been coming and been fixed after 2/8, my lord. These are writ petition 3846 of 25, my lord, 2432 of 26, 2562 of 26.
Mr.
My lord, find the reference in my annexure, my lord. I have annexed it.
Learned Counsel, appearing petitioner, Mr. Assistant, Mr. Polita. Sharma appeals for PTC, Mr. A. Fugan for appeals for respondent 1 and 2. The who's for 6, 5 and 6, 4, 5, 6, any Union of India, any
5 and 6,
CGC,
notice has to go for 5 and 6.
MSB Sharma for CGC, SCGC for respondent 4. I think 5 and 6, there's a standing council. NCT, who's NCT standing council? Mr. N. Alam. Where is Mr. Alam? Inform me. Who is for NEOS? Who is for NEOS?
Rekha R.
R.B. Bora. And Mr. N. Alam for respondent 5 and Ms. R.B. Bora for respondent 6. Since the respondents are represented, notices of waived, extra copy will be furnished in period of week. The petitioners claim to be holders of 18-month diploma in elementary education obtained from the National Institute of Open Schooling, NEOS, Open Distance Learning Mode, namely respondent number 6, And what is the meaning of where or are? Para 2? Where oblique are? Some of them are no longer employed.
Yes, maybe.
Where / are
The
employed
requirement
as
is
teachers.
before the cutoff date they have.
But if you must be employed.
Yes, before the cutoff date we were employed, man.
Before the cutoff date you are employed, then you are
No, Malaj.
non-employed.
You
It
cannot.
doesn't- It doesn't allow you to get back into employment by virtue of this judgment.
No,
If I've understood correctly.
No.
You must be in employment.
Employed. That's my specific.
And the NEOS degree has to be.
We are asking you where or are.
I'm not saying.
And the NEOS degree has to be prior to 1/4/2019.
That's my specific case, my lord. I've made specific averments, man.
No, they say that right, they are employed as teachers in primary or upper primary and upper primary unaided private schools on or before 10/8/2017. So it is their specific remarks that in deference to the advertisement issued by the BTC authorities, they offer their candidatures. However, in spite of fulfilling all the criteria, their names are not included in the select list as they were not considered to be eligible. As according to the BTC authorities, they do not have the required qualification and of the God, the diploma in elementary education before the cutoff date.
Without a cutoff date.
That was not the case, man. They said 18 months was not valid. 18 months diploma was not valid.
And that process of 2024 they are talking about was over in August 24. All appointments been made.
It is also submitted by the counsel for the petitioner that in most cases, the BTC authorities did not appoint the writ petitioner on the ground that this 18-month diploma is not a valid diploma. So he submits that his issue has been settled finally by the judgment of the apex court rendered in
Vishwanath and others versus State of Uttarakhand.
Vishwanath or Jaivir.
Jaivir was clarified by Vishwanath, man. Vishwanath clarified it.
That's right. Jaivir versus State of Uttarakhand, which subsequently came to be clarified by Vishwanath and others versus State of Uttarakhand, wherein it was clarified, it was held by the apex court that the teachers who had completed the diploma in elementary education from NEOS prior to the cutoff date and were employed were to be given the benefit of the diploma which they had earned. So that view of the matter, the counsel with the petitioner submits that the action of the respondents are contrary to the mandate to the judgment of the apex court. So, being agreed, the present petition is filed. There are Mr. Via on the other end has already filed an affidavit in opposition, which has been served, which has been brought connected to the case record this morning. And it is a specific case that the writ petition satisfy the criteria as they did not complete.
My lord, that 2024, my lord, prayer can in this writ petition, can you see the prayer? 17/1/24 advertisement dated and the affidavit in opposition paragraph 7. It will clearly. It is over. The selection is one-time measure. It is over. Prayer of the writ petition, my lord, can you see? A.
No, we are asking you why are they not selected?
They
What
were
is the
not
ground for rejection?
They were not selection. They doesn't come within the purview of my lord requirements with regard to this.
Why can't you put it that their degrees are recognized, not recognized, or they did not complete?
My lord,
diplomas.
My lord, first thing, they have not that 2024 process is over in August 2024 itself. So, my lord, there has been in the Supreme Court judgment, if the selection is over by the selection process, they not reopen this. First thing. Second thing, my lord, with regard to the qualification with regard to this, only 56 applicants were there in the review petition before the Supreme Court.
We are asking you something, you are giving us some different reply.
My lord.
We are asking you
yes,
that with whatever papers they have,
yes,
credentials,
they doesn't fulfill the requirement.
What is that requirement?
That requirement is this, that on 10/8/2017, there has to be on employment, my lord. First thing. Second thing, my
So you are
lord,
saying that in terms of the apex court judgment,
yes,
that judgment is applicable as a one-time measure for
Yes.
teachers who were already in employment
yes.
and they were not employed.
They were not employed, and apart from that, my lord, in 2024, my lord, they did not approach the Supreme Court also.
What does it matter?
My lord, and apart from that,
Unless you are saying that the judgment is a judgment.
because of the fact that the Supreme Court has observed that it is a one-time measure. If the process is complete, then, my lord, it is no question of reopening that.
The respondents submit that they do not fulfill the criteria and also that they were not in service to claim the benefits as given by the apex court, and therefore this writ petition is contained. Considering the fact, notwithstanding that the respondents have already filed their affidavits, then notice issued returnable in 4 weeks. Since the respondents are already represented, this has been issued. Well, issue notice on the interim prayer.
My lord, interim was already granted for the other petitioners, my lord, similarly situated, my lord.
Maybe what?
There's
what
a
is the point in
order of
keeping
the coordinate bench, my lord.
What is the point in keeping the post vacant?
Not vacant, should not be filled up, my lord.
Should not be filled up. You are not
I'll
selected.
clarify, my lord.
You are not selected.
I'll just
If
clarify.
you want to challenge somebody else's
No,
appointment,
no, I'm
you are
not
welcome.
challenging someone
No,
else's
we are
appointment.
not going through the selection itself. My lord, take my words.
My lord,
There is a
they have
stay order,
already
my lord.
appointed 56 similarly situated
No,
persons, my
this
lord.
is as per the Supreme Court
We
contempt petition, my lord.
appeared in the selection process, counseling was done, documents were verified. The only reason, my lords, we are not appointed because they say that 18 months diploma is not a valid diploma. That was clarified by the Supreme Court. What remains, my lords? And
My
the
lord,
other matter,
similar
BTC was
matter-
appearing.
My
BTC
lord,
was
Why
appearing.
are you asking for the post to be kept
Well,
vacant? For
because-
what purpose?
Because the posts were not notified. That advertisement, there were no
All the more reason no
notification
such
of the
interim
post.
order should be
Just,
granted.
my lord, as a abundant
No,
caution, my
what
lord, if it is
abundant
filled up, my lord, they may come up later and say that the posts are filled up.
Then you challenge the persons who were there.
My lord, again, that would be my lord, similar
Firstly,
under.
you have to satisfy us on merits after we hear the respondents that yes, you were otherwise qualified and you ought to have been.
No, I'm
appointed.
praying for an
That is
interim order now, my lord. It's not
we understand this interim order cannot be to the effect that the post shall be kept vacant and no teachers will be appointed. How is
Absolutely.
it possible? How will they run the schools? If it is the case that you are
Absolutely,
appointed, but you are now sought to be terminated, you are
So
given
in that case, my lord would say any appointment made would be subject to outcome.
exactly
Yes, let it be done.
any appointment
Because
which is
in the
made.
other matter, BTC had appeared, my lord.
The-
These objections are coming today, my lord. Fresh objections. They
The-
filed an affidavit on the first day without there being a notice, my lord.
That's not a crime,
Not a crime, my lord.
is it?
I'm assisting the court.
We'd appreciate if all the
All matters should be so prompt, my
departments
lord.
take such quick
Prompt
action. I think the state of Assam should take a cue from BTC. Chisti, even before notices are issued, the affidavits are filed.
Even staff problem.
Yes. Please ask Mr. Via for his secret.
Because there are other petitions, we same stand, my.
The appointments which may be made subject to the selection, which is subject matter of the writ petition. Challenge within the petition shall, however, be subject to the outcome of the writ proceedings. And such further orders as may be passed by.
Let this writ petition be listed along with 3846 of 25, my lord.
It is submitted by Mr. Via that these similar matters are pending. Therefore, this writ petition be listed along with WPC
3846 of 25, my lord.
3846 of 25.
Fine. Apply.
Deeply obliged. my lord.
Apply.
Timing item 9.
Should the petitioner has been working in Abhayapuri College since 1997 against a non-sanctioned post. Suddenly in 2026, Your Lordship, at Annexure 7, page 21, he is terminated by later, Your Lordship, by the prosecutor.
We should notice today what
Your
is
Lordship, notice, sir.
heard counsel for the petitioner issued notice. Returnable 4 weeks. Mr. S. Das appears for respondents 1, 2, 3, 3.
Well, actually, it is
Therefore,
not a
notices
necessary
respect of respondents 1 to 3 are waived, copies will be furnished within a period of within a period of 3 days, 3 working days. Steps of respondent 4 and 5 by speed post within 1 week. Service by way of trustee is also permitted, provided the same is entered through the registry of the court, and affidavit of compliance is filed thereafter.
matter.
Madly. The IA is for my lord including the opposite parties, that's my lord, that's
IA.
number 3 and 4.
IA.
For that, my lord,
IA is filed for
for including the opposite parties.
any objections?
No.
Heard comes in from the applicants. This IA has been filed for implement of the opposite parties. As the earlier incumbent was arrayed as respondents 1 and 2.
My lord, that's for 3 and 4.
Respondents 1 and 2 have since demitted office. Accordingly, this application, as such, this application has been filed seeking implement of the opposite parties and respondents 3 and 4. Presently, holding office as the secretary, Department of School Education and Director Secondary Education, respectively. Mr. SMT Chisti appearing for the Education Department, who had earlier represented respondents 1 and 2.
No, earlier I was directed by Honorable Court to apply because in this case,
Who was requested by the court to assist the court in the accompanying contempt petition. Submits that notice be issued in the IA. But considering the fact that but Mr. Chisti does not dispute the fact that the opposite parties are presently the incumbents in the offices of Director Secondary Education and Department of School Education and Director Secondary Education. Considering the fact that this is an application seeking implement the present incumbents in the office of the Secretary of Department of School Education and Director Secondary Education, sir, this court considers it appropriate to allow the IA for the present without issuing notice. Stop. The opposite parties, so and so, I arrayed as respondents 3 and 4 in contempt petition number 396 of 17. So I accordingly stand allowed disposed of. Petitioner will file amended post title in the IA, in the contempt petition. The contempt case, right, by virtue of the order dated so and so, passed in the IA, so and so are arrayed as respondents, parties number 3 and 4. Petitioner will file amended post title within 1 week. Thereafter, the matter will be listed before the court.
May I pray for a date? Because it is my case of 2017.
You file it, registry will list the matter immediately upon the amended post title being filed by the petitioner as directed by the court.
From 2018 to 2020, they were not appearing in this case, they were absent remain.
Sometimes.
But
the complaints cannot be ignored.
Meanwhile, Mr. Chisti will obtain instructions whether the directions contained in the order dated so and so, passed in WBG so and so has been complied.
And then I have got they have not aware of the pendency of this case because they have not served any notice.
My last order, my lord, the time was granted for submission of complaints report.
Yes.
All right.
Item 13, okay, director has already forwarded a proposal to the secretary for the area salary of the petitioner with effect from 18/10/1885 to 30.
When was it forwarded?
It was forwarded on 13/8.
It is submitted by Mr. SMT Chisti that the proposal from the Office of the Director Secondary Education for grant of area salary, the writ petitioner has claimed has been.
So now also
On the earlier occasion, it was advised that for the regularization of service, it was due.
Where is the direction of the court?
At page 10.
I think regulation work has already been done also. Certified that proposal has been sought by the secretary. I'll get an instruction, but I telephone I have informed that it was done.
It's been pending since 2016.
But if you're not regularized, this is the area salary for what? Which post?
Area salary receipts for the post of Assamese language teacher receipts.
By virtue of the, by the order dated so and so, passed in WBC so and so, the following directions are issued by the court. Page number 14. Then Mr. Chisti will obtain required instructions as to whether this order has been complied with, failing which consequential orders may be passed by the court. The next date only stay. Release this matter on 28th of August.
And you apply, sir.
Matter was placed before the mediation center where that matter was not settled.
Matter settled?
Not settled.
Not settled.
Not settled. Referred back to this process.
Matter was referred to mediation, however, the parties could not arrive at any settlement. Matter is therefore placed before the court. The pleadings are no affidavit filed.
Lordship, will file lordship on
Matter be listed on 28th, 26th of August, by which time the respondents may file their affidavit if so advised. Mr. B. Islam for the petitioner, MS N. Chaudhary for BTC, MS R. Dutta for respondent 3. 26th.
This review petition has been filed by the review petitioners for order date reviewing the order dated 1/4/21 passed in WPC 1641 of 2016. My lord. Here, my lord, the records will be essential. My lord, I have called for them. My lord. My lord will fix this matter on Wednesday. My lord.
Which order you are seeking to review?
Should order dated 1/4/21. Already there is a stay, my lord. This matter. But the records for hearing, it has come for hearing today. So I will need the records for the proper.
Where is that order? I want to see that order.
My lord, it is at page 24.
24.
Mr. A. Fugan, appearing for the state, submits that the relevant records will be necessary, which has already been called for. He submits that the matter be listed on Wednesday. Prayer made is allowed. Release this matter on Wednesday. Mr. A. Gupta appears for the respondent writ petition.
Can it be listed along with the contempt petition? Contempt is also filed. Contempt petition number 202 of 21.
Why? First hear the review.
The review has been filed 4 years after the contempt. Contempt was filed in the year 2021.
Is there a stay order?
There is a statement.
Then
There is.
how does it matter? There's a stay order. You file for vacating the stay order.
They have approached the division bench against the order of stay. The direction was to
Don't unnecessarily
dispose of the
make sufficiency. Let us you clear the review, then move for contempt. There is a stay order in the review. Yes.
TPM.
Has complied with the direction of the Honorable Court Lordship. The petitioner service has already been provincialized, Lordship. with effect from 1/10/2021 Lordship. This is the completion order. Hey, can you begin? Annexure to page 20 paragraph where Lordship mechanic that was
Yeah,
directed.
Mr. Khandakar, order complied.
My lord, no, my lord, there is a order to pay salary from 1/1/2021.
Where is the
Yes.
order of the High Court?
High Court, my lord, relevant, page 15, relevant portion, my lord, page 20, paragraph 12.
Yes, Lordship, to pay the salary from 1/1/21, his service has to be promised that we have promised with effect from 1/1/21, and that proposal will go, Lordship, for paying the area salary. That will give, he'll get it.
When it will go last from finance, my lord.
Because his
last of
proposal has to be done before that, Lordship.
The direction of the court by the order dated when she passed in WPC was to the following effect. There are 12, 13, 14, 15. So, whereas that order not being complied with, the contempt petition was filed pursuant to the issuance of notice. The matter has been listed in several dates. When the matter is called up. Counsel appearing to the respondents is placed before the court. The communication received from the Director of Elementary Education that the provincialization order number EED/126/2023/192 dated 13/08/26 in favor of the writ petitioner has been issued and his services have been provincialized.
With effect from Lordship 1/1/2021.
With effect from 1/1/2021. So what is the other claim? Area salary.
Area salary, my lord, that has not been paid.
Already,
The
DO has been directed by the
respondents submit that once the petitioner has been provincialized, now the steps will be taken for processing the area salary. The petitioner has directed. Consequently, this the area salary accordingly, part of the order, the directions contained in the PPC by the order dated has been complied with. Mr. M. R. Khandakar appears for the petitioner. He also submits that he has received instructions that the petitioner services have been provincialized. However, he claims that the area salary is still not released.
That will be released because now
How much time will it take?
Lordship, now his service has been promised with effect from 1/1/21. Now already Director has written there is a letter to the DO to submit a proposal.
Mr.
So,
Chisti
DO
has already submitted before the court that the director has already taken steps calling for the necessary report from the
district DO,
DEO, the concerned district, and upon completion of all formalities, the steps will be taken for forwarding the proposal to the
it will go to the finance Lordship after their approval.
finance, and upon their approval, the area salary will be released accordingly. Matter be listed after 8 weeks.
Yes.
4 weeks.
No, it will take time. It will go to the finance. It will take time.
We were thinking of closing it, but
Yes.
because a portion of the order is not complied,
Yes.
we are keeping it alive.
Yes.
List after 8 weeks.
Obliged.
By which time the respondent will apprise the court on the steps taken for payment of area salary.
Obliged.
May I please, Lordship? Lordship, this is a contempt petition and notice was issued.
AD card is awaited as per the official dated 5/8/2026. Release this matter again after 3 weeks.
The item number 18 is into similar matter, contempt
18.
petition.
Similar order. Yes, after 3 weeks.
In this case, I am paying for another 2 weeks time of to apply the code regarding the legislation.
In 2 weeks time. Mr. S.K. Das for the petitioner, Mr. P.T. Dokro, appearing with the respondents, prays for and is granted 2 weeks for the time to complete his instructions. Released again after 2 weeks on 7th September.
21 is also. 21 is.
Similar orders for 21.
Okay.
Content petition.
On last occasion, I paid for filing affidavit, madam. I have sent it from meeting, madam. 3 days time, madam, so that I can file it.
The respondents will file their affidavit by 19th.
Yes.
Matter be listed on 21st. MSP Bora appears for the petition.
Problem.
Respondent number 2 supposed to file affidavit.
Lordship, here the instruction is received, but Lordship, some clarification may be needed. Lordship may allow me 3 weeks of time, Lordship.
Mr. F.Z. Mazumdar for the petitioner, MS N.M. Sharma for the respondent who submits that further in time, prays for further time. 2 weeks. Complete her instructions and file affidavit. Released again after 2 weeks. By which date the respondents will file their affidavit based on 9th of September. Lordship.
25. My lord, as per office note of 11th of August, my lord, notice upon the private respondent is complete.
Await service report on respondent number 4.
No, that has been complete, my lord. Office note of there, it has been delivered 11th of August.
Okay. As per office note 11/8/26, as per postal receipt, postal journal, the item has been shown to be delivered to respondent number 4. Therefore, service can be deemed to be completed on respondent 4.
Lordship, I have submission, Lordship.
Yes.
There are connected matters, and I pray to take this matter along with the other matters. Review petition 77.
There is a problem is that there is a review petition pending and that review matter will be taken up for Honorable Justice Nelson Sailo. But if this is a fresh matter, my lord, if required, my lord,
Connected with the same order wherein inspector of schools has been
Lordship can connect. We can't transfer matters from one court to other. We can defer it. If you want to make a mention below that court, you do it.
So there are 4 matters along with this petitioner and other respondents. They have made party.
So have you filed your response here?
No, Lordship.
Are you intending to file it here?
Yes, Lordship.
Can you tell us how much time you want? 2 weeks
2 weeks.
to complete the instructions
2 weeks.
permitted to the respondents to complete instructions and file their affidavit. Release this matter again after 2 weeks, 9th of September.
interim order is there.
Interim order passed earlier will continue until further orders.
I'm deeply obliged.
9th of September.
I'm deeply obliged.
Yes.
No affidavit has been filed as yet. The response is required, madam. Secondary Education Department.
For the respondent. 3 weeks further time granted to Mr. Chisti to obtain instructions and file their affidavit. Release this matter immediately after 3 weeks.
May I plead for a
Mr.
date?
A. Bhattacharya appears for the petition.
May I plead for a date, madam?
14th September.
Obliged.
29.
So, Lordship, matter may be possible for time being, Lordship.
No timing. Who's for the other side?
Oh, so last occasion, last respondent took time to file.
Respondent will file their affidavit within a further period of 2 weeks. Release this matter again after 2 weeks. MS N Chaudhary for the respondent, MS so and so for the MSK for 1 for respondent 6.
I think that's not. Item 30, I have received an exception, I will file a affidavit.
Mr. Assembly Chisti submits that instructions have been received. He will raise for 2 to 3 weeks time to file his affidavit. Mr. N Sharma appears for the
On behalf of the person.
appears on behalf of Mr.
The person.
The Purkaster. The writ petitioner released after 3 weeks.
I'm for respondent 5. I'm
Mr.
for respondent.
Date may be fixed.
D Das appears for the respondent number 5. Yes.
After some time, 31 and 34 on behalf of the person.
No, what is the stand of the respondents here? Respondents, yes, what do you say?
I'm for the respondent number 1 and 2. Matter, some time is required, matter here, 2006 matter, and then moreover, it is matter, Dimahasao matter.
2 weeks further time granted to
Excuse
Mr.
me,
U. Sharma for the secondary education and who's for Dimahasao? Someone had appeared earlier, Dimahasao, standing counsel. Complete their instructions and file necessary affidavit. Mr. A. Sharma and Sharma, the petitioner, released after 2 weeks.
May I please, Your Lordship? Here, Your Lordship, what has happened, Your Lordship? There is an office memorandum by the government, Your Lordship. And this office memorandum says, Your Lordship, page 20, Your Lordship. The president of the governing body of colleges shall be an eminent person from the field of education. He shall be a non-political person. He should not have contested any election, including concert, municipality, local bodies election, and should not be an office bearer of the political party. That is at page 20, Your Lordship will find. Now, Your Lordship, this man, Your Lordship, who was the president, he contested election from the Somoria constituency, Your Lordship, in 2026, Your Lordship. And that has been brought to the notice of the director, Your Lordship, but no action has been taken by the authority till date, Your Lordship. And we have annexed the, Your Lordship.
The private respondent.
Yes, Your Lordship.
Hey, who are you?
I am, Your Lordship. One is guardian, Your Lordship, of the college, Your Lordship, school, college, Your Lordship. My student, my son, Your Lordship, is a student of that college.
Yes, education.
And in fact, Your Lordship may kindly see this, Your Lordship. There is a hearing also to have taken place, Your Lordship. On, that is, hearing had taken place on 15/6/2026, around 1 month back, Your Lordship. They have not passed any order on this also, Your Lordship. May I pray that they may be directed to, Your Lordship, pass this, the order on this hearing, Your Lordship.
Third, Mr. S. Motabu, City Council, assisted by Mr.
HM.
H.A.
And for the respondent number 5, Your Honor, I have received instruction. I have prepared the affidavit, Your Honor. However, the respondent number 5 is not well, so he cannot come and file. A short date may be given. I'll file my response.
File it within 3 days.
Yes, sir.
Mr.
J. Das, Your Honor.
J. Das appears for respondent 5. Mr. S. Mia for the state respondents. The counsel for the petitioner submits, senior counsel submits that challenge made in the writ petition is to the selection of the private respondent as the president of the governing body of which college?
Lordship, this is Your Lordship.
F.A.
Ahmed College, Kamrul.
It is submitted that the selection or election?
Selection.
Selection of the respondent number 5 is in violation of the OM dated 18/8/2017, wherein one of the preconditions, one of the eligibility criteria is that the person shall be a non-political person and he should not have contested in any election, including panchayat/municipalities/local bodies election, or should not have been an office bearer of any political party, or should not have any affiliation or membership to any political party. Mr. Motaku submits that the private respondent had contested elections in
2021, Your Lordship.
21 as a member of
Also
the
in 2026. 26, Your Lordship.
26 had contested elections with a ticket from AGP in 27 numbers of Moria LSC.
Lords.
So the selection of the petitioner as governing respondent number 5 as governing body was made on by which order?
Lordship.
Where was he selected? When was he selected?
He was selected
2022, 24/6/2022.
22.
Lordship.
For how many years?
5 years.
5 years.
5 years.
Although he was selected on the year 2022, for the year 2026, since he had contested elections, his candidature should be the petitioner's appointment as president governing body should be cancelled, since he violated the provisions of clause 3 of the OM dated 18/8/2017. Mr. J. Das appearing for the respondent 5 submits that he would like to file the affidavit within the next 3 days. Considering the prayer made, release this matter again after 10 days.
Lords.
By which date the respondents will file their respondent 5 will file their affidavit, and also the state respondent will apprise the court with respect to the orders passed by the director pursuant to a hearing which was taken by the director in response to the complaints filed by the petitioner.
Several complaints are there.
In face of the complaints received by the director's office regarding the appointment of the private respondent number 5 as the governing body, president of governing body of so and so college. The orders that may have been passed by the director should be placed before the court. The next date of listing, list on 28th
Lordship.
August.
Deeply obliged.
This matter, my representation is pending before the director. Your Lordship kindly see page 21. So matter will refer to director, page 21. I filed a representation before the IS referred the matter to the director, but no decision has been taken. My case is, my lord, I am entitled to get retirement come casualty retirement benefit as per section 135(3).
I'll obtain instruction, madam. Get instructions. Yes, madam. Mere disposal will not help you.
Yes.
Yes, madam. Mr. J. Ahmed, Mr. N.J. Katonia, standing counsel for the secondary. Yes, madam. Education is submits that you'd like to complete his instruction. Released again after 3 weeks. 11th September. Hello. Yes.
May please, Your Lordship, we have taken steps and the private respondent has appeared and the affidavit is not yet filed.
The respondents are permitted to be further time to complete instructions and file necessary affidavit. Mr. S.P. Sharma. Mr. You are appearing for respondent 5.
5. File the vacating.
Stay vacating.
Because my lord, I am the senior most fisherman.
Right, respondents will complete their instructions and file necessary application.
My interim order.
Interim order passed earlier will continue.
Much order.
That's maybe
11 September.
Order. Much order.
Interim order to continue till 11.
Please, your lordship, my senior is coming. Kindly take this matter after some time, my lord.
That's not a ground for adjournment for time being. You are there, you argue. What is the matter?
We are supposed to bring instructions, my lord, in this matter.
You supposed to bring. You. What happened to your instruction? What has happened to your instructions?
It is not known to me, lordship. My senior has taken instructions from me.
Hey, you are appearing before the court, you must have all instructions. The request made by the counsel to the petitioner, matter stands deferred, be listed after 1 week. MS P.K. Bora appears for the petition, for the state.
Apply.
In this statement, I'm paying some more time to bring the records. I'm paying for some more time to bring the records for the order.
The records.
Yes.
Records was it called for?
Yes,
Yes,
my
yes,
lord.
ma'am.
Number, ticket number. Earlier on.
Records as called for have not been received by the respondent counsel. She prays for the 2 weeks time. 1 week time. Get it. Release this matter again after 2 weeks. MS gave S. Supriya for the elementary education, K. Fugan for state, and Mr.
R. Bora on behalf of P.K. Teka for respondent number 5.
R. Bora on behalf of P.K. Teka for respondent 5. Mr. H. Ali for the petition. Released after 2 weeks. 11th September.
May I please, your lordship? Lordship, as per the last order, we have approached his lordship, and then he was pleased to issue us a declaration, and here are the copies.
You submitted to the registry. In deference to the earlier order dated 28/7/2026, whereby Justice Mir Alfaz Ali, former judge of the Gauhati High Court, was appointed as an arbitrator. Subject to the written declaration required to be furnished under Section 12(1) of the Arbitration and Conciliation Act 1996. Justice Ali has furnished written declaration dated 8/8/2026, which is placed before the court. By the same written declaration, Justice Ali has expressed any difficulty or hardship in acting as the sole arbitrator to decide and arbitrate on the disputes arising by and between the parties pertaining to contract agreement executed by and between the parties. In that view of the matter, the appointment of Justice Mir Alfaz Ali, former judge of the Gauhati High Court, is confirmed as a sole arbitrator to act as a sole arbitrator between the parties. The parties will appear before the sole arbitrator appointed on. When do you want to appear?
Any date?
28th? 28th of August? 28th of August?
Yes.
28th of August. The parties, when appearing before the sole arbitrator appointed, will place a copy of this order, and thereupon the learned arbitrator will initiate the arbitration. Stop registry, communicate a copy of this order, Justice Mir Al-Fazali from Judge of the Court here. Disposed.
Much obliged, Your Lordship.
There are two matters.
Same model.
It's 25.
It's 20.
The written declarations are retained in the case record. Same order, but the contract numbers are different. Yes. Yes.
Only the speed of last order, 23/7.
Yes.
Matter pertains to selection and appointment of the private respondent number 9 with the younger brother.
Pleadings are complete.
Complete
Yes.
Then we put it for admission hearing on 18th. Tuesday. Since the pleadings are complete, the matter will be listed for admission hearing on 18th.
Obliged.
Mr. Patgiri for petitioner, Mr. Mannan for
9.
respondent. 9, MSK for state.
Obliged.
Here, I am appearing for the finance department, Lordship. We have received a parawise from it. Here, Lordship, certain decisions.
My Lordship, I'm on behalf of BK Das Lex in another court, maybe pass over for the timing.
Please.
I'll pray for,
some time.
I'll file in my affidavit, Lordship. Our affidavit will be required.
Mr. Talukdar has made a prayer on behalf of Mr. DK Das, counsel with the petitioner. But the matter be deferred for some time. Mr. H. Aliha, standing counsel finance, on the other end, submits that he has received his instructions. We'd like to bring the affidavit of record. Stopped by the earlier order dated 22/7/2026. The finance department was directed to apprise with regard to the status of sanction or approval, if any, granted by the finance department, the proposal forwarded by the PTC for regularization of the services of the petitioner.
As per instructions, we have not received.
No. In this context, Mr. Chalia submits that the affidavit by accordingly, prayer made is allowed by on behalf of the finance department. Release this matter again on 28th. By which date the finance department will file the affidavit. That's
Lordship, it's only for appointment of arbitrator, so there is no provision in railway Lordship regarding mediation. They did remain in this court, Lordship, on the next occasion. If I could not file my affidavit, Lordship may appoint an arbitrator. Today is the
It is
notice regarding.
submitted that matter be listed. The matter is fixed for the returnable date. Has come after the returnable date. Ms. D. Sharma for the respondent submits that she be permitted further 2 weeks' time. Complete the instructions in the matter. Mr. A, you are Mr.
And Thakuria for S.
N. Thakuria appearing in behalf of Mr. S. Sharma, who is not object to the prayer made. Release this matter again on 11th of September.
Okay.
Yes.
Doctor, this has come from appointment in the special mediation drive. We have no objection if the case is sent to mediation.
Counsel for the petition submits that there is no objection if the matter is referred for mediation.
Seniorism, I don't-
Maybe, but it's for the petitioner to decide if they want to go for mediation, why should you object? What is your name?
PR Chaudhary.
MSPR Chaudhary appears for Mr. Raj Gupta appears for the respondents. Petitioners do not object for mediation.
But section 11 petition will not have.
No, they don't.
We decided
Sort
by
it
the
out,
court
let them
only.
sort it out. What is the question of that? Do you
Once they
agree to
have
their, do you
approached-
agree to their appointment? So section 11,
My lord.
are you
Since the
filing an objection?
Yes, my lord.
Therefore, see if it can be sorted out unless you say that you agree for appointment of an arbitrator will appoint.
My humble information, once they have approached the section 11, agreed procedure been failed. It is the only the court which has to decide. It
That's
cannot be
right.
referred for.
But there's nothing wrong in trying for mediation.
My lord.
Unless you agree that yes, we agree for the appointment.
No, my lord, that I have to
Then
file affidavit.
matter be posted for the mediation. Parties will appear for mediation on 28th of August.
Doctor, 46 also similar.
Similar order, 26.
Obliged.
Item 55.
Mediation, we send it to mediation, you see, we can sort it.
I have no problem.
Yes. Parties are agreed that the matter can be attempted to be resolved with mediation, right, undertaken based on 28th.
In first week of September.
First week of September.
Can it-
2nd of September. 2nd of September, parties will appear with the committee of mediation. Second. Yes.
May I please, your lordship? My lord, the petitioner has qualified the recently concluded NEET examination, my lord. And my lord, admittedly, he appeared from, my lord, in the state of Rajasthan, from nearby Kota, my lord. And therefore, my lord, a provision has been notified at page 46, annexure 5, my lord. My lord, may I kindly have a look at page 46. This is the case, crux of the case, my lord. Clause number 2, my lord. Page 46, annexure 5. It is to be mentioned here that the government of Assam, by its gazette notification number dated 29/12/2025, has omitted the clause 3(1)(c) of the Assam Medical Colleges and Dental Colleges of Assam Regulation so and so rules 2017. Accordingly, candidates who appeared in the NEET UG 2026 from another state of the Union Territory but belong to the states of Assam, having PRC of Assam and who are otherwise eligible as per the so and so rules 2000 amended up to 2026 may apply to this directorate in plain paper with valid documents to the office of the undersigned, second floor, on or before 11th of August 2026 during the office hours for inclusion of their names in the provisional Assam state merit list. No further applications will be considered by this office after the last date of submission, that is 11th of August 2026 during office hours. My lord, admittedly, I have, my lord, missed out this cut-off date of 11 because, my lord, I belong from Mankachar, South Salmara area, my lord, wherein the internet connectivity is less, as well as, my lord, may kindly see the window is this notice is issued on 5th of August 2026. And the window is very narrow, my lord. Only it is for a period of 5 days, my lord. So therefore, my lord, I missed out and I made a representation of late, my lord. Admittedly, on, my lord, page number 52 is the, my lord, type copy and 53 is the, my lord, copy. My lord, can peruse page 52, my lord. So, my lord, along with this, though I approach, but my lord, the director of medical education, in view of the cutoff,
You are saying,
my lord,
submitting that you belong to Mankachar
Mankachar.
and you therefore internet connectivity is there, not.
But not very, my lord,
Look at your representation at 52. You say that you
my
are
lord.
examining, you were in Kota, Rajasthan.
No, my lord, that is, my lord, that is the condition, my lord. I passed the NEET examination appearing from, my lord, state of Rajasthan. From, my lord, may kindly peruse my examination NEET result, my lord, which is available at page number 44, my lord, annexure 4, my lord.
Then,
My lord, that's why, my lord, if I want to avail the, my lord, Assam state list, if I want to get admission, my lord, in the Assam state list medical colleges, then an opportunity had been given by amending the rule by the health department, my lord, as well as this educational notice had also been issued, my lord.
so you have to submit by
11th of August to make an application that I want my enrollment or my name should be included in the provisional list for the Assam medical colleges, my lord. So that cutoff date I have missed out, my lord. Only that technical difficulty, my lord.
What do you say?
My lord, because that educational notice it specifically says that it is after 11th August, my lord, no application will be received, my lord. Because already a list has been prepared and that has been duly published, my lord. My lord, if that application made by the petitioner, I have now inquired with the office, my lord, it has not been received there. And otherwise, my lord, in the application also nothing has been stated as to why he could not submit within time. And regarding 5 days window narrow period, my lord, normally during the admission process, everybody is aware that it has to be done in an expeditious manner, my lord.
So that's what I'm saying, that what you are submitting and what is there in your records, there is a difference.
So, my lord, what has happened, my lord?
You
I
are
have-
submitting
Yes,
that you
yes,
were in Kota, then you came to Mankachar, which is your residence, permanent residence.
Permanent.
Because of lack of internet, etc., you would not apply. Look at your representation at 53.
Oh, my lord, it is a very short, it is a very, my lord, hurriedly, and he is a student, my lord.
Whatever it may be, we go by whatever you've given.
No, my lord, the director, he also went personally, he met the director of medical education, my lord.
Can't be extended. You show us how it can be extended. If it is extended for you, it has to be extended for everybody.
No, my lord, the law, my lord, which has been recently, my lord, enumerated by the Honorable Apex Court, my lord, actually, can it be taken at 2 p.m., my lord? I will try to satisfy, my lord. Matter of my lord.
Meanwhile, you get your instructions to see if anything can be done to accommodate by one more day or something.
A student's career is in danger, my lord. That's why. Otherwise, I will not have.
Depending on the number of applications that are available.
My lord. My lord,
Yes.
My lord, so therefore, my lord, I have missed out this cutoff date, and now, my lord, as a not extraordinary, my lord.
Anything can be done, Mr.
My lord, because we have to go by the educational notice, my lord, because there may be some other candidates also, and secondly, on the basis of the candidates who have applied till 11th, my lord, the merit list has already been published.
Provisional.
Any instructions you have? No?
Yeah, that is the instruction I have received, or telephonic instruction from the DME, my lord. And otherwise, we have to go by this notice, my lord. Yes, sir. Because the petitioner has missed the bus, my lord, and while submitting application, my lord, he has not made any justification.
That's a different issue, justification.
Yes, my lord, I
is
understand.
secondly, but how many applications are there like this?
That I can actually the DME is also in Delhi in connection with some official schedule, my lord.
DME there, but his office is here, no?
Yes, office.
His office will be able to tell you.
And they are also working, my lord, all the office bearers, because that instruction also I can have, but within such a short time, my lord.
How can there be a direction, Mr. Bhuya?
My lord,
Unilaterally in your case.
My lord, if we go by the notice, my lord, this notice has been made pursuant to an amendment of the original rule, my lord, which I have understood, my lord. If my lord may be pleased to peruse from second paragraph, my lord, it is to be mentioned here, my lord, at page.
When is the next, what do you call it,
No, my lord, this provisional merit list has been published. Now, final merit list has not yet been done. If we go by the notice, my lord, it is at page number, my lord, 47, my lord. If my lord may be pleased to peruse this educational notice, admission into the course of medical so and so Assam for this session. This is for all concerned that this director advised so and so. Merit list of so and so prepared and is hereby published in the official website of this department so and so. So, my lord, this list, if we peruse from the next page, my lord, 47 and 48, it appears to be a provisional Assam state merit list of NEET. UG finalized, it has not yet
What is
been
the
done.
next step after that?
My lord, after this, if we go by the rule, my lord, they are required to scrutinize the particulars, my lord, and then the final merit list will be published for counseling.
My lord, next.
When is the next date for counseling?
Next date of counseling. Next date is, my lord. Online registration for first round of counseling. And for that purpose, date is fixed, my lord, 13/8/2026 to 15/8. Since yesterday till tomorrow.
These persons are required to register provisional. Then from this registration,
You're not allowed to register.
Because this application for outside quota, Assam state quota has not been accepted.
You get instructions by Monday to see if there's anything can be done. That's all we can do. I mean, what else? What order do you want from them?
Lord, if I make an application with citing all details, my lord,
do it.
Then, my lord, till Monday they will take a decision, my lord.
Yes,
And my lord can, my lord,
let him file a detailed representation.
by tomorrow, my lord, if it is open.
They're bound to be not open.
So tomorrow we approve.
You filed it today itself.
Yes, yes, my lord. Today also I
And
can
this
do.
is the subsequent notification, my lord, subsequent schedule, my lord.
I heard counsel to the party, the petitioner is candidate who had cleared NEET UG 2026 from Kota, Rajasthan. So, under the procedure prescribed, the state government had issued the educational notice dated 11 August 2026, informing all concerned that the admissions into MBBS/BDS courses in the government medical and dental colleges of Assam will be as per the Assam, within quotes, Assam colleges and dental colleges of Assam, bracket regulation of admission into first year MBBS/BDS courses, bracket close, rules 2017, and all candidates whose names and roll numbers are present in the Assam State Provisional Merit List of NEET Undergraduate 2026 will be eligible to participate in the counseling if otherwise eligible. Stop. The Learned Senior Counsel submits that the petitioner is a resident of
South Salmara, Mankachar,
South
the state of Assam,
Mankachar,
having all other requisite qualifications.
satisfies all the other requisite qualifications. However, considering the poor
internet facility, my lord, in the said area,
communication facilities, including internet facility within the vicinity of the district of South Salmara, Mankachar, the petitioner was not able to have access to the notice, educational notice dated 11th of August 2026. As a consequence thereof, he was not able to apply, and his name did not figure in the provisional Assam State Merit List of NEET Undergraduate 2026. So, filed a representation before the Director of Medical Education, requesting him to include his name in the provisional list so that he can participate in the
Counseling process.
Counseling process reserved for the Assam medical or dental
Mal.
colleges. Stop. Apprehending that his representation will not be redressed, the petitioner has approached this court, praying for urgent orders. Mr. D.T. Bora, appearing for the respondent, submits that once the notice is issued and other students have already applied, and the petitioner having not applied, his name did not appear in the provisional merit list. Standing counsel has further placed before the court subsequent educational notice dated 12/8/2026, whereby the schedule for online registration has been published, which provides the online registration for counseling will commence on 13/8/2026 to 15/8/2026. So it is submitted that it is only the names of the candidates whose names appear in the provisional merit list will be eligible for registration for the counseling. First round of online counseling for admission into first year MBBS/BDS courses of the government medical and dental colleges of Assam for the session 2026. Considering the prayers made, this court deems it appropriate to permit the petitioner to file a detailed representation explaining his conditions before the DME Assam before the expiry of the date mentioned by today.
By today,
during the course of the day, explaining his conditions, the request. So, the said representation if filed will be considered by the DME sympathetically, and if thereupon pass appropriate orders. Redressing the grievances of the red petition. Needless to say, any such application that may have been filed, any order that may be passed, copies thereof shall be served on the red petition. Petitioner is permitted to file the proper application through email, physically.
Physically,
You can go and file, my lord.
Because of the notice
File
also.
the application physically before the authorities. And any such order that may be passed can be communicated to the red petitioner through the email address which petitioner will intimate the DME authorities. With the above observation, without any opinion on the merits of the case, red petition stands disposed.
Email or WhatsApp, my lord. WhatsApp may be
Email and contact number.
yes, my lord.
But can the matter will keep pending, my lord, what decision they take?
Then it becomes a different cause of action.
If they allow, I have to